The second case I wanted to mention under this convention is derived from my practice, and it relates to the child's property, and I thought that was particularly interesting because it is sort of examples that you can only see in practice and couldn't imagine in theory. So in that case, a child lived in Australia, and his great aunt lived and died in France. And in her will, she gifted this child a fifth of a house located in France. Then I received news from the French notary, which under the French system is the only person who can administer an estate and sell a house. And in France, what the notary would normally do, before selling the house on behalf of a child, what you have to do under French law is to obtain an order, a specific order from a judge who's looking after the interest of the child, even though the parents have parental responsibility. So the notary contacts me and wanted to know more about what the law was in Australia in relation to ensuring that the interest of the child in relation to real estate were protected. He didn't mention it, but I think, and this was fair enough, that he might have been worried about his professional liability also, knowing that he couldn't obtain that order from the French court. So the solution, thanks to the convention, is the following. Is that the mother of the child who is residing in Australia can file proceedings in the family court seeking to be appointed as a guardian of the child in relation to this property and any dealings with the succession and the estate in France. The decision of the family court qualifies as a protection measure as stipulated by the convention and widely defined in Article 3. So the appointment of the mother as a guardian in Australia is automatically recognized in France by operation of law. And so, thanks to this mechanism, the notary was aware of what protection mechanism we have in Australia, and thanks to the automatic recognition in France, his responsibility was presumably protected as well. And the last convention I wanted to address this morning is the Convention of 1961 on the conflicts of laws relating to the form of testamentary dispositions. As you would guess, every country has a different legislation as to the formal requirement in relation to wills. And so the Convention very simply and effectively provides 5 grounds for the recognition of the validity of testamentary dispositions made in a foreign country. And it's very simple. The will has to comply with one of the 5 grounds set out by the Convention. And those are if the form of the will complies with the internal law of the place where the testator made the will, if it complies with the law of the nationality possessed by the testator, either at the time he made the disposition or at the time of death, or of a place which the testator had his domicile, either at the time he made the disposition or at the time of his death. So it's very broad. Or of the place in which the testator had his habitual residence at the time the will was made or at the time of death, and in relation to immovables, the place where they are situated. So the legislation implementing the convention in New South Wales is Section 48 of the Succession Act 2006. So you will find these 5 grounds and I think a few extra under Section 48 of the Succession Act. And to date, this convention has 42 contracting states, so in practice it comes in quite handy as well. So another case study that is also derived from my practice in relation to this convention. I'm not too sure exactly where it's going because it's ongoing, but without disclosing any advice, I can give you the broad facts and where this is going under the convention. And Section 48 of the Act, which is very straightforward. The deceased dies in a civil jurisdiction where the formality relating to the validity of a will are much less specific than in New South Wales. That means that a handwritten will with no witnesses executing the will is still valid. So this is what we're starting with in terms of our foreign will. Now the will deals with properties overseas and also in Australia and real estate. When the deceased dies in a civil jurisdiction where the concept of grant of probate doesn't exist because they're not going through courts but they're going through a public notary, obtaining the reseal of a probate might be difficult. Something I haven't dealt with yet, and I'm looking forward to it, but I'm sure it's going to be very interesting to try and explain to the court what the equivalent is and whether they will satisfy the court. So here we are with a will that is handwritten, no witnesses executing it, and what someone would like in Australia is a grant of probate in relation to the real estate located in Australia. So what happens thanks to the convention is that the testator has complied with the domestic law relevant to the testamentary disposition of the place he or she made the will. So thanks to the operation of the convention, the will is recognized as valid as to its form in Australia, even though the will didn't respect the requirement as to form of the New South Wales legislation. So now this is becoming theoretical, but I've got good hopes that thanks to the operation of the convention, it shouldn't be an issue to obtain probate in Australia. And I'm not talking the receipt of a grant of probate, which never existed in the other jurisdictions to start with, but since we're starting with a will that is valid in Australia in terms of its form, obtaining probate in Australia should be easier. And the consequence of that is that this will enable the executor to administer the estate and any eligible person in New South Wales to file a family provision in relation to the real estate located in New South Wales. So many aspects of family life are covered, as you saw, by the conventions I touched upon today. And as explained by Christophe already, additional family matters such as adoption, child support, spousal maintenance, and the protection of adults are addressed by other Hague conventions. From an Australian perspective, as mentioned by Ian Coleman MLC, there is a major area which is not covered in Australia, is the question of spousal property in the context of international divorces, whether in presence of prenuptial agreements, as they are called worldwide, or not. And there are two reasons for this vacuum. First, Australia is not a party to the Hague Convention of 1978 on the law applicable to matrimonial property regimes. So that's in instances where you don't have prenuptial agreement or financial agreements, as we say in Australia. And second, there is no Hague Convention addressing the issue of the recognition and enforcement of foreign prenuptial or antenuptial financial agreements. So that's the major area in terms of family law that will need to be covered in the future. Thank you very much.
I actually own a factory of pens. But Rick, I'll get to tell him every time. Well, thank you very much. Really appreciate it. Top marks to you, and to be fair to David as well, top marks to David for his contribution. And thank you very much on behalf of myself and Rick for your contribution today as well. Thank you.
Thank you.